Be seated. All right, we actually see them walking in?
They're just a couple doors down.
Okay. All right, well,
I've had an opportunity to read along with Mr. Shaw.
is this it, this one-page thing from the 3rd DCA?
No, it's a Supreme Court, United States Supreme Court case.
Yes.
Right.
And
It
I'll give
stands-
you
Oh, well,
mine.
they denied cert, right?
Well, no, they said it was an error to exclude the testimony, so I don't know.
Oh, okay. Well, let's take a look at it.
Well, I don't think it said that.
Well, the position the defense was taking is the exact opposite as what the case holds. The case holds Bedard was a qualified and appropriate expert to offer this narrow evidence for the jury, and his exclusion, based on his other areas of prior admitted expertise, constitutes a prejudicial and reversible abuse of discretion. So it's the exact opposite proposition that the defense was
Okay.
indicating.
Okay, well, I'll tell you what, it's noon now, so let's bring the jury in. We'll give them an hour for lunch, and then we can read this more carefully and proceed accordingly.
It's in this 138 Supreme Court.
All right, very good. Members of the jury, inasmuch as it is lunchtime now, we'll go ahead and we'll give you lunch and be back in an hour, which would be at 1:01. So we'll see you at 1:01. Thank you. All right, so we'll all get an opportunity to read this, and then what time do we want to be back to discuss it? 12:50, 12:55?
Judge, we need to speak to the state about deposing a witness as well, so we might need a little more time.
Deposing a witness? What witness?
A defense witness that they may want to,
I don't need to depose that witness.
well, we do.
You need to depose your own witness?
No, well, we're going to call her, but it's a state witness that we're going to call,
You listed her as a witness.
but she was also listed as a state witness, Your Honor.
I'm not saying.
All right, well, if you're going to call her, you can talk to her off the record, right? I assume it's Ms. Hicks, I'm guessing?
Yes.
Yes, Your Honor.
All right, I'm a good guesser. All right, so you can talk to her off the record and figure out if you want to put her on the stand or not.
We've done that, but we want to take her deposition and make sure we have impeachment if we need it.
She's your witness, so
Well, still was listed as a state witness, Your Honor.
now, she's your witness. If you want to put her on at your own risk, okay? You don't take depositions of your own witness. They've listed her because they have to list everyone who may have some knowledge about the case. You've listed her, and now you want to put her on. So if you want to put her on, that's fine. If you want to talk to her ahead of time and figure out what she's going to say, that's fine. But we're not going to take time out for you to depose your own witness.
Understood, Judge.
Okay. All right, so what time do we want to come back? 12:55?
Yeah, that's fine.
Okay, see you then. Thank you. Oh. All right. I left my notepad in there. It's a spare, so I'll just live with the spare. Okay, are we ready for the jury? Right on time, too. I wonder if they know how lucky they are that we've been on time most of the time. All right, let's go ahead and bring them in.
Yes, Your Honor. Your Honor, do you want the witness on the stand first?
Yes.
Your Honor, the jury is present and seated.
Very good. Welcome back. Mr. Rosenwasser, you may continue.
Thank you. So before the break, we were about to talk about threat assessment, so let's talk about threat assessment. Okay. Would it aid you in talking about this by using easel just to write down the terminology?
Perhaps, yeah, I mean, it'll make a nice record of it, what I'm going to say.
May the witness step down?
You may step down.
Okay, what are the four terms that you're going to discuss?
Generally, when we are talking about threat assessment, wondering whether or not something is about to occur, we're looking for four criteria. Here in the state of Florida, for law enforcement officers in particular, we tend to look at three and then we mention the fourth criteria, but not necessarily as an evaluative purpose.
Okay, could I have you write down the
Sure.
terminology on this pad?
So the first criteria that we try to look for is the subject's ability to do us harm. This is really critical when it comes to deadly force incidents, since of course that's a final act. It's something that a person would try to understand, does this person have the ability to cause me death or great bodily harm, or somebody else death or great bodily harm? And ability may mean, for example, and I can come up with 100 examples, but to keep it simple, I'll take a knife. If I possess a knife, I would say that I had the ability to cause somebody death or great bodily harms. Most of us, knowing that the cutting edge of a knife can cause lethal injuries, would agree. But if I was standing across the room, knives aren't intended to work that way. They have to be generally in closer quarters. So the second part of our evaluation for threat assessment means opportunity. So for example, again, if a law enforcement officer is facing somebody with a knife in their hand and knows that they have the ability to cause death or great bodily harm to them or someone else, it's prudent for the law enforcement officer to gauge the distance, for example, of how far the knife would actually work, and to hold their fire and to not use deadly force in response to justifiability unless they could justify that the opportunity had made itself available for the person to then injure the officer or another person. So opportunity matters. So a lot of times, for example, if you see somebody walking towards an officer who is issuing verbal commands, the officer will hold the trigger until they feel that there is sufficient distance for them to be in danger. And at that point, we would say from an evaluation perspective, okay, the person now has both the ability and the opportunity to commit deadly force. Now, it could also be said that anyone who carries a knife, perhaps some of you do when you're walking around in the street, and perhaps some of you who use a knife in your occupations, would have, when you walk close enough to somebody, both the ability and the opportunity to use that knife. But you lack something else, and this is part of our evaluation. And that third thing is what here in the state of Florida we refer to as intent, but more universally,
I'm sorry, refer to as
intent?
okay.
More universally, it's known as jeopardy. And the reason that the term intent is not used so much is because, of course, we don't always know what the person's intent is. So we have to infer intent from their actions, from their statements, from the way that they may be making threats to us, or in some cases, it may be something as simple as something we knew from the past. So based on the fact that they have the knife and they are close enough, now we have to examine whether or not that person is actually meaning to do us harm. And so we have to decide if we're in jeopardy as a result of that. So that would be the third criteria in threat assessment. The fourth criteria comes to us mostly through statute. And it's the idea, as I mentioned to you earlier, that deadly force is a final option. Certainly in law enforcement and in society, we try to preserve lives, don't try to end them. And so we use this concept of preclusion. In other words, is there anything else I could have done? Is there anything else that I could have reasonably done to prevent myself from taking another person's life? So an example, going back to our knife, if a person has an edged weapon of some type and is close enough to cause harm and means to cause harm, I would have to then evaluate that fourth criteria. Is there something else I could do to preserve this person? I'll give you an example. Police officer answers a call at night where there's an alarm going off in an empty warehouse. Of course, they get called to it. They arrive on the scene. They go inside an open door. And as they look onto the floor, there's an individual there that has a knife in their hand. Probably that individual has brought that knife to do harm to somebody. It's an empty warehouse. The officer knows that. As they open the door, they find they're close enough for the person to do harm. They also find, of course, that they've identified the weapon, there's ability. And they feel in jeopardy. The question is what stops the officer, for example, to walk back outside the door and close it, and perhaps set up some type of a response with other officers to contain that environment, to keep that person inside the building. Perhaps we can talk them out. peacefully, by not creating our own exigency, by not putting ourselves in harm's way intentionally. So these are the 4 criteria when we're looking at use of force that we examine when we're looking at police use of force, but also when police officers are looking at civilian use of force. Whether or not these criteria are in place or not will be the decision on whether the officer feels as if the force was used as a measure of self-defense or unlawfully.
Okay, so let's talk about that for a second. We're going to talk about the concept of justifiable use of deadly force, okay? Because in this particular case, it was deadly force that was used, correct?
Yes.
Okay. Now, you're using law enforcement. The standard for justifiable use of deadly force, is it the same between law enforcement and civilians?
Deadly force, yes.
Correct.
Exactly the same.
Okay, so even though you're saying law enforcement, it still applies to civilians, lay people. It's the same justifiable use of deadly force.
Yes.
Okay. Now, when we're talking about, let's just say, hypothetically, okay, you're using a knife as an example. What about if there is no weapon?
If there is no weapon, then you would say that there's perhaps no ability. Now, ability can be found in other ways. I don't want to leave you with the impression it's only a knife that can cause harm. Ability can be done also based on relative size. It can be done, if you show up and there's a person that has 4 dead bodies laying around them and they're coming after you, you can assume ability. So there's many different ways of looking for it, but absent a weapon, generally speaking, this is diminished. This first one is diminished.
Okay, and you said if you go through 1, 2, 3, 4, you really have to get through all 4 to have a situation where the use of force was justifiable.
Yes.
So 1, maybe iffy. Now let's talk about opportunity. Okay. So you were using the edged weapon as an example, and that you typically, unless you were a ninja warrior or something, you wouldn't have the ability to throw the knife, okay? But let's say someone was standing still, not going forward. Would that be an indicator they didn't have the opportunity?
Well, perhaps if they're standing still, depending on how close they are, they might have the opportunity, but they may not have the intent. So there's no external factor that tells the person who's about to use force that I am under direct threat.
Okay. And would it be fair to say that for opportunity, if they're standing still, the distance between them would be a factor?
Yes.
Okay. What about if that person was moving backwards?
It would generally be an indication of retreat, and of course that would start to diminish once again our evaluation for the use of deadly force.
Okay.
I'm sorry, Judge, I have a little trouble hearing sometimes because he's talking to the back. Can I relocate?
Yes, you may relocate.
Did you hear the last answer?
I'd like you to repeat it because I moved it, sorry.
If someone's going backwards.
Wait until she's ready.
All right, we'll do it 3 or 4 times.
Thank you.
All right, if someone's going backwards, how would that factor into opportunity?
What I indicated is that would diminish the threat naturally. It would represent a form of retreat, not somebody who's advancing, but rather pulling away from an active threat.
Okay. And what about someone that went backwards and then turned away?
Once again, that would be an indicator, I think, for most people. Generally, when we fight, we face the target. All animals do that. We become binocular. We try to receive as much information as possible. So anybody that turns away generally takes their center away from the other person would be indicative of somebody who, once again, is starting to diminish the active threat.
Okay. So with 1, 2, 3, and 4 here, you have, a question up here, but in the hypothetical we're talking about someone going backwards or going backwards and turning away, more or less the opportunity is pretty much diminished.
Yes.
Okay. And then there's no need at that point really for deadly force.
Right, I think it would actually, this still applies. The question is, am I in jeopardy? And the answer to your scenario is no, I'm not in jeopardy.
Let's talk about some other terminology that was used. You indicated before that when you were watching the defendant's statement, he used a term called force multiplier.
Yes.
Okay, and you indicated that perhaps the way he was using it, and
I'm sorry, Your Honor, can he return to the witness stand now?
Well-
If he's done with the chart?
well, he's not done with the term.
Oh, I thought you were finished with
In
that.
fact, I have 2
Line
more
of
things.
questioning.
Just so you know, I have 2 more.
Okay.
And just to read exactly what the defendant said regarding force multiplier. The defendant stated, so makes me believe to myself I need a force multiplier because I don't know what's going on. The detective says, what do you mean a force multiplier? What is that? Then the defendant says, you know what a force multiplier is. The detective says, no, sir, I don't. The defendant says, well, a force multiplier is a sidearm. Anything other than your hand, a stick, some type of weapon, force multiplier. Okay. When we talk about force multiplier, is the defendant using it correctly?
No.
All right. So explain to the members of the jury how what he's saying in his own statement is not correct.
I wasn't surprised that the detective didn't understand the term. It's mostly used in the military sciences, not in law enforcement. And it's mostly used for procurement, actually. When somebody is about to purchase something, what they're trying to do is get more efficiency, for instance, out of their employees, or in the case of the military, perhaps their soldiers. So force multiplier can be used for a lot of abstract things. Like, for instance, if you're guarding some area, it makes more sense to put up a fence because you don't have to walk as far, see as far, and do as much. So a fence would be considered a force multiplier. If I try to relate it to law enforcement, and bearing in mind, I think I told you earlier, I sell police products as well, and this is where I hear the term. The concept of, for instance, pepper spray would be a force multiplier. Because it has the ability to clear a whole room. You can have one officer spray pepper spray and everybody leaves. I think what I heard Mr. Drejka talking about is actually a force continuum, or a escalation of force, rather than some concept of being able to do greater things. I suppose you could imagine a firearm allows you to do greater things, but what it really allows you to do is address that single person with a more extreme level of force, not necessarily deal with multiple persons that it would otherwise take multiple people to do.
Okay. So instead, let's talk about force continuum.
Okay.
Are there different levels in a force continuum?
There are.
Okay. Is there a graph that you could draw that describe for the members of the jury, or a table that would help?
Sure. A force continuum, I should tell you, is used in law enforcement as well. It's used all across the country. It's even used in the federal system. And because of that, there are different terminologies, but I'll try to keep it simple for you because it is a fairly simple understanding. Today here in the state of Florida, we call it force options. These are basically what an officer would consider appropriate and measured and proportional to the threat that they're facing. So the intent of showing you this is to show what we've decided and has been examined many times as being proportional levels of force. So generally speaking, when you're looking at force continuum, if I can take this chart and divide it into two pieces, I'll put over here our threat or potential threat, and then I'll put over here response. Now, in law enforcement, we refer to this as resistance because law enforcement officers are empowered to do things that civilians aren't. They're empowered to enforce laws. So the resistance component means that if somebody is starting to resist an officer's lawful command, they may use force where the average civilian could not. You asked me earlier about deadly force. Remember, we don't ever kill anybody to effect arrests, and that's why it's the same for law enforcement and for civilians, because law enforcement only use deadly force in defense of themselves or others, as do everyone else. So there are some parts of this that are enforcement oriented, but the other parts of this have to do with self-defense. And so I'm going to put both of these up here so you can understand the threat level. Perhaps I'll give you some examples to clear it up, and then the response level. So if you start at what we consider the lowest level of force, and this goes from lowest to highest, the assumption being that every level provides a more extreme answer to a particular identified problem. Extreme meaning it does more harm. So the lowest level of threat we might have is presence, and I'm sorry, I don't normally write upside down, but I'll do my best to keep it clean. Presence can be a threat, for sure. If you have somebody who comes in and is acting and behaving a certain particular way, you may feel a little threatened by that. It doesn't mean you can do anything about it, but it certainly will capture your attention. It will provide a visual cue for you for situational awareness, to be aware that something is happening. So in response to that, because you can't do anything, your level of control, if you will, would be your mere presence as well. In law enforcement, we know that presence influences behavior. If somebody's doing something illegal and a person in uniform shows up, The officer might not even know that something illegal is going on, but usually that illegal stuff stops. So we consider it a level of force because it's influencing behavior. So presence meets presence, and that would be proportional. The next level of threat might be directed. It would be...
If we could approach the other position.
Okay. Yes.
So we were talking about force continuum, and you were starting to say that the second level is verbal and continuum.
So verbal resistance, if you will, would be somebody who could be cussing you out. If you're a police officer and you are told to do something and you argue, that would be considered an escalation of force. And this is all about escalation, de-escalation, and proportionality. That's the idea of this chart. So the verbal level of resistance or threat would cue somebody that their mere presence may have to be stepped up. And to remain proportional, you can counter it with verbal instructions, you can dialogue, you can give warnings, you can do all those kind of things. But it remains verbal. We're not using any type of physical force. It's still very low level. It's a level 2 response to a level 2 threat. Now, assuming that the subject escalates again, the lowest level of escalation from this point is what we would call passive escalation. This might mean, again, if you're a police officer, you tell somebody to do something, they just don't do it. Perhaps they behave as if they didn't hear you, or they sit down intentionally to force themselves to be moved. This passive level can also happen, of course, in the civilian world, in the security world. Trespass is a good example. You have to leave here. You have to leave my house, and the person refuses to do it. That would be a passive level. In response to that, the appropriate level of force generally is empty hands. These are the things, the techniques, the defensive tactics that are taught with respect to what you're born with. Your punches, your kicks, your elbows, your knees, your grabs, your grips, your throws, all those kind of things would be empty hand. There's no weapon being introduced into the environment at this low level of resistance. It is a threat, but we're not introducing weapons. The next level is what we call active resistance. Active resistance generally means you're trying to overcome somebody. So let's talk about the civilian set. I'm in your house. You tell me to leave. I don't do anything. You grab me, and I snatch my arm away. I've escalated. I've tried to prevent you from taking authority. In law enforcement, there are far more examples because law enforcement has much more authority. When they are called to a call, it doesn't have to be their own home before they can make somebody leave, for example. But generally, it is not a direct attack on the officer. We're not there yet. It's not a direct attack on the civilian. We're not there yet. So typically, we counter this with what we might refer to as intermediate weaponry. Intermediate weapons. And there are many of them out there. Law enforcement carry a whole bunch of them. We have things like pepper spray. We have tasers. We have batons. Civilians carry things like that too. They carry pepper spray. Sometimes they carry personal tasers. And this is about the time when you would start considering escalating to that level. Intermediate weapons mean that my empty hand tactics are ineffective, but I can't justify the use of deadly force. So that's kind of how we lump this category together. Assuming that there's escalation, we would go from active to what we call aggressive threat. Aggressive threat means the fight is on. Somebody's actually doing something to harm me. They're attacking me. They're running towards me, swinging their fists. They're attacking in some sort of way. Not in a deadly situation. It's not a case where somebody may be drawing for a weapon. That's a different category. It's a higher category. But they're aggressively attacking. The way that I would suppose most humans fight all the time is with their aggressive, barehanded skills, not escalating to lethal force. At this point, if you find yourself in a fight, we consider it reasonable to use what we call temporary incapacitation. I'll have to abbreviate that because I'm out of space. Temporary incapacitation means that you're hitting back. You're either trying to knock back, knock down, or knock out. You're going for areas that are going to cause an effect. You're trying to cause somebody to stop their aggression, to de-escalate. And you're doing it with, for instance, punches to the face, kicks to the solar plexus, arguably neck restraints, things like that. Things that don't kill you, but stop you temporarily. So that's the next level.
Before you get to the next level, so just by way of example, you've been talking about proportionality. So let's say that someone is at level 1, presence.
Yes.
As a response, could you jump to 5?
You could, but it would be considered, by our definition, unreasonable.
Okay. So same thing at presence, would it be unreasonable to go to 4?
Yes.
Unreasonable to go to 3?
Yes.
Okay. So basically, going across, that would be the proportional
Yes.
and allowed response.
Yes. So all of these should correspond. Now, I should say it works in reverse. For example, if somebody attacks me aggressively and I decide to have words with them, that's okay.
Your Honor, can we approach another picture?
This instruction, that your instructions on the law will be given by the judge at the close of the case. The witnesses are not in a position to give you instructions on the law, and you're not in a position to follow what they may instruct you on as far as what the law is or your interpretation that they're instructing you on the law. The only law that you should follow are the instructions that the judge gives you at the close of the case. You may continue, Mr. Rosenweiss.
And it is the sixth one.
Just-
Oh, sorry. I apologize. Thank you. And is the 6th level the final level?
Yes.
Okay.
So the ultimate level, obviously, is if somebody
Same objection, Your Honor. It's continuing again.
All right. Go ahead.
if somebody prevents what's called an aggravated threat, it generally means that they're aggressive and have the ability to use deadly force against you or somebody else. And the appropriate training instruction for law enforcement, self-defense classes, things like that, is we meet aggravated threats with what we call deadly force. So this basically constitutes what's called a force continuum that's based on force options. It's based on threat assessment, understanding the conditions of the environment based on visual cues, and responding to them proportionally.
Now, in the defendant's statement, he also brings up something that he calls the 21-foot rule, and we're going to talk in detail about it. First of all, have you ever heard that term before?
Yes.
All right. Is there such thing as a 21-foot rule?
No.
Okay. Can you explain?
Can you go back to seat now? Are you done with the chart or not?
We had one more chart.
One more chart.
One more
okay.
chart.
All right, I'm sorry.
The last and final chart. All right, so the 21-foot rule is not really a rule, but you heard of the terminology.
Yes.
All right. What is it? What is the 21-foot rule, so to speak?
A little history. 1983, a law enforcement officer from Salt Lake City, Utah, by the name of Dennis Tuller, discovers probably what you already know, and that is that there is such a thing as reaction time. And Tuller wrote an article in the SWAT magazine entitled, "How Close is Too Close?" Meaning, when you are addressing a threat as a SWAT operator, generally speaking, how close is too close before you'd be able to react to a very specific threat? And that threat is somebody with an edged weapon. Fast forward to 1988, a company called Caliber Press produced a video called Surviving Edged Weapons, and they played out the tooler drill, which is what we refer to it as, using multiple trials, multiple officers, to examine what Tooler had concluded, that it takes time for you to be able to get your weapon out of your holster when you first identify a threat. So when you first identify a threat, the assumption is if that person is actively attacking, they're covering distance, how much space would you need to be able to actually address a knife attack with a firearm? Obviously, you have to get the gun in your hand first. And I don't know if you're familiar with modern law enforcement holsters, but they're designed as safety holsters to keep the weapon in. There's a lot of interesting straps and snaps and blocks that's configured into the design that's very specific to hold the weapon in if somebody grabs it. And that's good, except if you're trying to quick draw, it takes you a little bit of time to get it out. You've got to undo those straps and snaps and maneuver around those blocks to get the weapon out. It's generally assumed that it's going to take about 1.5 seconds. We've tested it, we've examined it several times. So that's what the tooler drill was. It was an expression of how far back should we start pulling our weapon and addressing the threat with 2 shots in 1.5 seconds. And when they examined it, they generally said it takes more than 20 feet. This is all based on what we call a quarter-second reaction time. The ability to perceive something takes about 0.18 to 0.25 seconds. Your hand moving back, about 0.18 to 0.25 seconds. Grabbing the weapon, 0.18 to 0.25 seconds. Doing all the magic to release it, 0.18, 0.25 seconds. Drawing it, about a quarter second. Extending it and addressing the target, about a quarter second. So there's about 6 things going on there. And if you multiply that times 0.25, you'll come up with 1.5 seconds. So that's what the drill was. And it has actually had a lot of influence on training, both in the civilian environment and in law enforcement. There are drills now that are conducted at what we call the 7-yard line when you qualify NRA courses, when you qualify for law enforcement. There's a moment where we'll stand you 7 yards from a target and give you 1.5 seconds to pull your weapon and address the target in that time frame. So that's the test, if you will. But it's not a rule. It's really just sort of a healthy respect for understanding that somebody standing close to you that may have an edged weapon could do real harm before you could get your weapon out of the holster.
Okay, just a couple things to talk about. So one, this tooler drill was really designed for law enforcement.
Yes.
Okay.
Well, by law enforcement for sure.
Okay, by law enforcement, really in training law enforcement.
Yes.
All right, and you indicated just something about the holster. A holster for law enforcement may, by design, be a little more difficult to take a firearm out of.
Yeah, they're significantly sophisticated.
Okay, and that would then factor into the time frame.
Yes.
All right, but it sounds like what you're testifying is that there's 3 components of this tooler drill, which the defendant refers to as the 21-foot rule, correct?
Yes.
Okay, so the first component, would that be that in the drill, the officer has not yet unholstered the firearm?
Yes.
Okay, could we write that as number 1? So that would be the firearm is still in the holster. Okay. Number 2, you were saying that in the tooler drill, the person that had the edged weapon was advancing.
Yes.
Okay, so could you put that, number 2, that the person or aggressor, however you want to say it, is advancing?
It's critical that I include edged weapon because that's what the drill is about.
Okay, and that was going to be the third position. The third important part of the tooler drill, which the defendant referred to as the 21-foot rule, is that the person that is advancing has an edged weapon.
Yes.
Okay, can you put that as the third principle, we'll call it?
I'll put retains edged weapon because there's some possibility that your appraisal may conclude that they've dropped it along the way.
Okay, now, common sense, edged weapon would be a knife.
Yes.
Anything else that you would think of?
Anything sharp, screwdrivers, bottles, machetes, I suppose you could even argue a ballpoint pen, something that could puncture, slash, cut in some way. That's generally what we're training the tool or drill against.
Okay, so, for example, you have to have all three,
Yes.
okay? So if you don't have one, tool or drill or 21-foot rule doesn't even apply.
Right.
If you don't have number 2, doesn't apply.
Right.
Don't have number 3, doesn't apply.
That's correct.
It doesn't mean that if someone's within 21 feet of you, you can just automatically shoot them.
Absolutely not.
Now we're finally finished.
Okay.
I got you.
You said you had an opportunity to watch the video, is that correct?
Yes.
All right, I want to direct your attention just to one very specific point in the video. Nothing else at all about the video, okay?
Okay.
Okay, one very specific point. Did you watch the video and did you see the defendant's hands when he pulled out the firearm and pointed it?
Yes.
Okay. Did you have an opportunity to see any movement when he was holding that firearm?
Yes.
Okay. And based on your training experience and your expertise, what did you see when he took the firearm out? What type of movement did you see?
I saw two movements previous to the shot breaking that were sort of fanning or waving to the left.
Okay. You didn't see the firearm going up in the air or out of control or anything like that?
No.
Two distinct movements to the left.
Yes.
Didn't get the impression that the firearm wasn't being controlled?
No.
In fact, the opposite, it was being controlled.
It appeared to me to be.
Time to move, Your Honor. Thank you.
Thank you. Cross-examination.
Thank you, Your Honor. Good afternoon, Mr. Bedard.
Good afternoon.
All right. Let me begin by just clarifying for the jury, other than what you just talked about with the trigger issue, the gun movement, you're offering absolutely no opinion as to what Mr. Drejka did in this case, correct?
No.
All right. So you're not saying what he did was justified or unjustified. You're not indicating anything like that to the jury, correct?
No, just that I noticed it.
Okay. So I just wanted to make sure we were clear on that. And you're not an attorney, correct?
That's right.
And it's up to the court to instruct the jury as to what the law is with regard to the use of self-defense, justifiable homicide, and excusable homicide. Isn't that correct?
That's correct.
And there are 3 actual defenses that can be asserted by any defendant accused of, in this case, manslaughter, correct?
Yes.
All right. And you're not offering any opinion about that?
Members of the jury, let me go ahead and just reiterate this again, that your instructions on the law will be given by the judge at the close of the case and not actually during the trial. So obviously that's the law that you should follow. It's what the judge gives you at the close of the case. You may continue, Mr. Trevino.
Thank you, Your Honor. Now, Mr. Bedard, you have no idea what Mr. Drejka's training consisted of, correct?
No.
And you did view the video of his statement, correct?
Yes.
So you know that his father was a 20-year veteran of the state trooper,
Yes.
highway patrol, correct?
Yes, sir.
All right. So obviously he comes from a law enforcement family, correct?
Sounds like it.
All right. So we don't know where he picked up those terms. It may very well come from his family. It could have come through his concealed weapons training, correct?
Yes.
All right. And just because you use certain terms in a certain way doesn't mean he was taught that way, correct?
Well, he used the terms. I was elaborating on them.
I understand, but I'm saying you don't know what training he was given. Maybe that's what he was told. You don't know, correct?
I was just defining terms. I'm not trying to characterize anything that might have went beyond what he said.
Understood. Now, one of the things that you have stated in the past in other cases, and you've advised, and I think it's even on your website, that before a law enforcement officer is interviewed after a fatal shooting, that at least 24 hours should elapse before a detailed interview is conducted of that officer. Isn't that correct?
Yes,
And why is that?
because when you're involved in what we call critical incidents, oftentimes you don't process correctly. Your memories become fragmented. You don't have a full understanding necessarily to what has occurred. And as a result, sometimes you can become very impressionable, and sometimes you can even create facts that aren't necessarily there because you're trying to fill in those missing pieces.
Understood. Very well put. Now, another thing that you have on your website is you've been involved heavily in the stand your ground issue, correct?
I have.
And in fact, you have a video on your website that talks about stand your ground, correct?
Probably.
And in fact, you've consulted with 2 governors about stand your ground laws?
Not directly.
Indirectly? I mean, it's on your
Indirectly,
site.
yes. I mean, when there was a conversation about the law, I had written a few pieces on that.
And in fact, on your website, you say, if I may, Dr. Bedard, several things you state on your website. One, your right to stay alive is the most fundamental and natural right a person has.
That's correct.
In the case of self-protection, that is an important, fundamental, and natural right that humans share.
Yes.
And lastly, a person's sovereignty and their ability to protect themselves is the most important thing, and everything else after that can be debated about later.
I agree with that.
Thank you. I don't think I have any other questions.
Thank you. Any redirect examination?
May I have a moment, Your Honor?
Yes.
Defense counsel just asked you about some quotes on your website, correct?
Yes.
Okay, and you stand by those, correct?
Yes.
I mean, this case doesn't change that at all, right?
No.
All right. And those principles would apply to anybody in a situation, correct?
Yes.
All right. So it would apply to anybody's life. Anybody's life is important, right?
That's correct.
And you look at all the facts and circumstances to determine who was at fault, who wasn't at fault, right?
That's right.
Thank you. I don't have any further questions.
Thank you, sir. You may step down.
Thank you, sir.
All right. Is he released from the subpoena, everybody?
No, he'll be on
No?
standby.
Okay, you're on standby. Thank you, sir.
Sir?
State, please call your next witness.
Dr. Palma? Dr. Noel Palma?
Do you swear or affirm the evidence you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, thank you.
Right this way. Go ahead and have a seat. Speak aloud for your voice with court, please.
Thank you.
Good afternoon, doctor.
Good afternoon, sir.
Mr. Schaub, you may inquire.
Thank you, Your Honor. Good afternoon, Doctor. Will you please state your full name for the members of the jury?
Good afternoon. Sorry. My name is Noel Palma, Noel Palma.
And what do you do for a living?
I am a forensic pathologist and work as an associate medical examiner here for the District 6 Medical Examiner's Office, serving Pinellas and Pasco counties.
Jury selection. Somebody actually said one of their favorite shows is Quincy.
Oh,
All right. So tell the members of the jury what a forensic pathologist is.
a forensic pathologist is a branch of medicine that deals with medical legal cases. So basically, it is a sub-branch or a subspecialty of pathology.
And what type of training do you need to give in forensic to become a forensic pathologist?
Okay, so you need to do residency in pathology, anatomy pathology, and clinical pathology. After that, you need to take your boards, and then you need a subspecialized training in forensic pathology in a medical examiner's office.
And of course, before you do all that, you have to get your medical degree.
Yes, sir.
All right. And did you, in fact, get your medical degree?
Yes, sir.
All right. Where did you get your medical degree from?
In the Philippines.
All right. And then you came to the United States?
Yes, sir.
All right. Tell us where your training has taken place in the United States.
I was trained at St. John's Hospital Medical Center in Detroit, Michigan, in both anatomic pathology and clinical pathology.
And where did you receive, was that your residency?
Yes, sir.
All right. After getting done with your residency, you decided that forensic pathology was something you wanted to specialize in?
Yes, sir.
All right. And where did you go to receive your initial training after your residency?
At the Wayne County Medical Examiner's Office in Detroit, Michigan.
I imagine that kept you pretty busy.
It's a busy place.
Yeah. All right. How long were you in Detroit?
Total of about 5 years.
All right. And what type of things did you do with the Wayne County Medical Examiner's Office?
Doing medical examiners cases like doing autopsies and also testifying in court.
All right. And after finishing up your period of time in Michigan, where did you then locate to?
Palm Beach County for about 2 years.
All right. And how long, or what office in Palm Beach County were you with?
The District 15 Medical Examiner's Office.
Is that when you met Dr. John Thogmartin?
Yes, sir.
All right. And eventually John Thogmartin became the Chief Medical Examiner of Pinellas County.
Yes, sir.
Did he bring you with him when he located here to Pinellas?
I came here about less than a year later,
All right. And what year was that?
2001.
All right. And how long then have you been with the medical examiner's office here in Pinellas? And it's Pinellas and Pasco, correct?
That's correct.
Pinellas and Pasco counties.
About 18 years.
Total number of years as in the pathology field?
So 20 years as a forensic pathologist and about 5 years total for training.
All right. Now, some of us have heard of pathologists at a hospital, something like that. How's what you do differ from a pathologist? Let's start with a pathologist at a hospital.
All right, so pathology practice in the hospital, what they do is they run the labs, they do blood banking, and they read slides, they do biopsies.
And that's not what you do.
No.
All right. You do a forensic work.
Yes, sir.
Eventually going to have to perhaps appear in the court to give opinions and testimony.
Yes, sir.
All right. And, boy, how many, have you testified in courts before?
Yes, sir.
All right. Approximately how many times have you been recognized as an expert in the area of forensic pathology?
Hundreds.
All right. And typically how many autopsies might you perform in a typical year?
Over 200, 250 cases or so per year.
All right. And what are some of the types of cases that are required autopsies under law?
All right, so any kind of drug-related deaths, traumatic deaths, homicidal cases, and a lot more.
And your offices are located where?
At Olmerton Road,
All right.
Largo.
So you said you do autopsies sometimes with homicide type cases.
Yes, sir.
Were you called upon in this case to perform an autopsy?
It was my on-call day, so basically I'm on call or cutting that day.
All right, and
Yes.
I prefer the term on-call rather than cutting. So you were on call that day?
On duty.
You were on duty?
Yes.
All right. And did you happen to be the one to perform an autopsy on Mr. McLaughlin?
Yes, sir.
Have a moment, Your Honor. You may. If I may, Your Honor, just for a second. Do is talk to you a little bit about the autopsy that you performed. What was the date of the autopsy?
This is July 20th, 2018 at 10 in the morning.
At this time, Your Honor, may we have stipulation number 2 read?
When parties agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated fact that you must accept as true is as follows: that the autopsy performed by Dr. Noel Palma on July 20, 2018 at 10 o'clock a.m. was the deceased Marquise McLaughlin, and the identity of the decedent in this case is Marquise McLaughlin. You may continue.
Thank you, Your Honor. So you performed an autopsy on Marquise McLaughlin.
Yes, sir.
All right. Can you tell us what an autopsy is?
So basically an autopsy is a post-mortem examination of a decedent, usually performed by a pathologist or a forensic pathologist. So it is a complex medical surgical procedure that consists of thorough examination of the body, including internal examination or dissection of the internal organs in order to determine the cause and manner of death.
And you do that in a facility here in Pinellas County down on Elmerton Road?
Yes, sir.
All right. What is the first thing you do when you start an autopsy?
Basically, what we have is, what we do is get the height, get the weight of the patient or decedent, and then we take pictures, document the external injuries, and then we take x-rays just to check or see where's the, in this particular case, the projectile, and then proceeded with an internal examination of the decedent by dissecting each organ and also following the wound path.
Right. Height of Mr. McLaughlin?
73 inches or 6'1".
And weight?
205 pounds.
All right. Now, you make your observations. When you made your observations of Mr. McLaughlin's body, what did you note?
So there were a medical treatment and also a gunshot wound.
All right. When you say medical treatment, what are you referring to?
There was ET tube in the airway, and a chest tube in the left thorax.
All right. And is that more or less normal procedure?
Yes, yes, sir.
It's a life-saving
Correct.
technique used by emergency medical technicians.
Yes, sir.
And that was done in this case?
Yes.
All right. Tell us a little bit about the purpose of an autopsy in homicide purposes. Is it to determine the manner and cause of death?
To determine the cause and manner of death, yes.
Okay, cause and manner of death. Could you tell us what you mean when you talk about the cause of death?
Cause of death is an injury or a disease process that killed a person or caused the death of a decedent. An example will be a gunshot wound or hanging or drug overdose or myocardial infarcts.
And what is the manner when you talk about manner of death?
Manner of death is an opinion based on the circumstances surrounding the death of the decedent, in corroboration with the autopsy findings and laboratory procedures. There are 5 classifications of manner of death.
Go ahead.
All right, so there are 5 classifications of manner of death. First one is natural, when someone died of a purely natural disease process. An example will be a myocardial infarct.
I'm sorry, what was that?
Sorry, myocardial infarct or heart attack.
Okay.
Accidental death. The best example will be a drug overdose or a traffic-related event. Homicidal death when someone is killed by another person. And then suicidal deaths, hanging is the best example I can give you, and undetermined manner of death when we do not know the circumstances surrounding the death of the decedent.
All right. And did you determine the manner and cause of death in this case?
Yes, sir.
All right, and I want to talk about something. Your agency that you work for, the medical examiner's office.
Yes, sir.
You're not an arm of the prosecutor's office.
No, we are an independent entity.
You're not the arm of the sheriff's office.
No.
An independent entity.
Correct.
You can testify for the defense, you can testify for the state, you can testify in civil cases.
Yes, sir.
All right. So in this case, did you determine the manner or
Yes, sir.
Of death?
Yes, sir.
Okay. And what was the manner of death?
It's a homicide.
Did you determine the cause of death?
Yes, sir.
And what was the cause of death?
It's gunshot wound of chest.
All right. Now, as part of the autopsy on Mr. McLaughlin, did you have photographs taken of items of the injuries, of the chest x-rays, of the projectile that caused the death?
Yes.
All right. Prior to coming in and testifying, have we sat down and gone over those photos together?
Yes.
And did you point out photos that you felt might be helpful?
Yes, sir.
All right. For the jury understanding your testimony.
Yes, sir.
Can I approach the witness, Your Honor?
You may.
I'm showing you what's been previously marked as state's exhibits. A through F. Do you recognize those photos?
Yes, sir, and as you can see here, my case number 518-1195.
All right. These photos, 1, 2, 3, 6 of them, do they fairly and accurately represent the injury that you observed to Mr. McLaughlin that caused his death?
Yes, sir.
I'm showing you what's been previously marked as State's Exhibit 28. Does this photo fairly and accurately show you the location of the entry wound?
Yes, sir.
Within where it's located on the body of Mr. McLaughlin?
Yes.
And I'm showing you State's Exhibit number 29, not a composite, a single photo. Does it show you, I guess it's not an exit wound, but it's a bruised area where the bullet was lodged on its way out of the body?
Yes, sir.
And does it fairly and show you the location on his body where that wound is?
Yes.
This time, Your Honor, we'd offer into evidence the State's Exhibits 38 through F, 28 and 29. I'm showing you.
Approach, Your Honor.
Okay. Here's a further instruction. Please disregard any show of emotion that you may have observed or will observe from anyone in the audience or anybody else, obviously, except for perhaps the witnesses. All right, you may proceed.
At this time, Your Honor, may I have the witness step down?
You may.
Doctor, let's first start with the entrance wound. Now, you indicated that there was resuscitation applied to Mr. McLaughlin.
Yes, sir.
And that's what type of a tube?
There was a chest tube on the left lateral thorax, on the left chest, and 2 needle decompressions on the anterior chest.
All right, and I think this picture shows that, so I just want you to point out to the jury what you're talking about. And it has nothing to do with the shot, other than the life-saving technique.
So here's the chest tube, right here, and there are 2 needle decompressions on the anterior thorax.
All right, and those were applied by emergency medical?
Yes, sir.
Okay. Let's take a look at what this photo shows. Let's talk about an entry wound. What is an entry wound?
An entrance gunshot wound is it's a perforation to the skin in this case, and it is due to a projectile. In this case, it's from a gun.
All right. And could you point out to the members of the jury where that entry wound is located?
It's right here in the left lower chest region, located at or centered at about 2 inches below and to the left of the left nipple.
By the injury itself, are you able to make any type of a determination on what type of an instrument may have caused it?
Yes.
Okay, what's that?
And in this case, it's a gunshot wound.
All right. Are you able to make a determination as to what type of gun might have caused it, or what
caliber?
Caliber, yes.
No.
Okay. Now, you also indicated, I don't know if to call it an entry or an exit wound, but it's an exit, at least a abrasion, correct?
There was a near exit wound on the right upper lateral chest region, as you can see here, right here, located at about 2 inches above and to the right of the right nipple.
All right. On my body, could you show the members of the jury exactly where that entry wound is and that entry wound is and that exit wound? The entry, let's start with.
The entry was located at about 2 inches below, 2 inches below and to the left of the left nipples. Somewhere around here. It's hard.
Right here.
Okay, so somewhere here, about 2 inches below and to the left of the left nipple. The exit wound was located at the right lateral thorax, about 2/3 above and to the right of the right nipple below the armpit.
And is it consistent with, point out to the members of the jury the exit wound.
It's a near exit wound. The bullet's still here.
All right. Did you eventually remove that bullet?
Yes, sir.
All right. Now, the path of that shot.
The wound path was from front to back, left to right, and upwards.
Is it consistent with someone shooting another person from a sitting position?
Yes, sir.
All right. Raising the gun from a sitting position, the path of that bullet is consistent?
Yes, sir.
All right. Now we're looking at State's Exhibit number, 30A through F. Could you tell us there in photograph A, what are we looking at?
All right. Photograph A showed an entrance gunshot wound centered at about 2 inches below and to the left of the left nipple, right here. This is the chest tube, left lateral thorax. B showing a close-up picture of the same entrance gunshot wound. C is the location where the bullet was recovered and the right upper lateral thorax. It is there's a near exit wound here with a small laceration. And this D is the close-up picture showing that the same injury is a near exit wound. And
Let me stop you for a second. So the path of that bullet that it took, did it hit any major arteries?
it hit the left lung,
Okay.
the heart, and the right lung.
All right. So it hit his left lung, Mr. McLaughlin's heart,
Yes,
and his
right lung.
right lung. Would it have caused death pretty quickly?
Yes.
Okay. Now, what are we looking at in photograph E?
E showing the bullet that I recovered from picture D, and F is the x-ray that we took prior to the autopsy showing the projectile near the edge of this x-ray right here.
In part of your autopsy, did you do a diagram
Yes, sir.
of the entrance wound
Yes,
and the exit wound?
it's the bullet, where the bullet was recovered.
All right. Again, not an exit wound because the bullet was at the fleshed area.
Yes, sir.
All right. At this time, Your Honor, we'd offer into evidence State's Exhibit 27. No objection. It's admitted. And I know this is your diagram that you performed, that you did, but to your best estimate, is that the location on the body where you found the entrance wound
Yes, sir.
and the exit wound?
It's,
Or
yes,
the
sir.
bullet recovered area?
Right, it's here.
And it was going from,
From front to back, left to right, and upwards.
thank you, Doc.
Thank you.
Now, as part of your autopsy, do you also have, do we have a toxicology department here at the medical examiner's office?
Yes, sir.
All right, and that's ran and operated by a toxicologist?
Yes, sir.
Was a toxicology report done on Marquise McLaughlin?
Yes, sir.
Is that customary in a homicide autopsy?
Yes.
Is it customary in all autopsies?
Most autopsies.
All right, but homicide autopsies, we normally do it, correct?
Yes, sir.
All right, and was it done in this case?
Yes.
All right, I know you didn't do it. You have any objection if I introduce him? I'm just going to have him make this. So you have your toxicology report that you received from your toxicologist.
Yes, sir.
What is a toxicologist?
Toxicologists they are scientists that do toxicology cases.
All right. And was there a determination made as to whether or not there was a drug in Mr. McLaughlin's system?
Yes, sir.
And what was the determination?
Blood showed MDMA and MDA.
MDMA
Correct.
and MDA.
Yes.
All right. We have a moment, Your Honor. Thank you, Doctor. I have no further questions.
Thank you.
Cross-examination?
Good afternoon, Doctor.
Good afternoon, sir.
Mr. McLaughlin was 205 pounds, correct?
Yes, sir.
He was 28 years old when
Yes, sir.
when he died, and he was 6 foot 1 inch tall.
Yes, sir.
Okay. You said you opined that the manner of death is homicide.
Yes.
That doesn't have any legal significance as to whether or not it was a justifiable homicide.
No.
Okay, just means one person killed another.
Yes, sir.
Okay. And you also said that you found Schedule I controlled substance MDMA in his blood?
Blood and urine. Yes, sir.
And urine. And you also found MDA metabolite of the psychoactive drug MDMA in his blood and urine?
Yes, sir.
Okay. And you retrieved one projectile?
Yes.
Okay. He wasn't shot a bunch of times?
No.
Okay. Moment, Your Honor.
No further questions.
Thank you. Any redirect?
No, Your Honor.
All right. Thank you, sir. You may step down.
Thank you.
State, please call your next witness.
Dr. Bruce Goldberger.
Stand next to me. Raise your right hand. Take the oath. Hands out loud, please.
Do you swear or affirm the evidence you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank
Or
you.
this way. Go ahead and have a seat. Speak from the microphone loud. Clear voice for the court.
Good afternoon, sir. Mr. Rosenwasser, you may.
Good afternoon. Can you please turn to the jury and state your first and last name, and for the court reporter, just spell your last name.
Good afternoon. My name is Bruce Goldberger, Goldberger.
Okay, and how are you currently employed, sir?
I'm employed at the University of Florida in the College of Medicine in the Department of Pathology. I'm professor and director of toxicology and chief of the Division of Forensic Medicine.
Okay, and how long have you had that position?
Well, I began at the university about 25 years ago as an assistant professor and director of toxicology, and I've been promoted throughout the years to my chief position as well as my professor position.
We're going to be going through your background, training, experience, and education in just a second. What do you do in your current position? Can you tell the members of the jury?
Well, relevant to today's case, I am director of the Forensic Toxicology Laboratory at the University of Florida. The laboratory serves 5 medical districts across the state of Florida, not this current medical examiner district, but other districts, and we work about 2,500 cases per year. I'm also a part-time consultant to the Centers for Disease Control as a toxicologist.
Let's talk about your educational background. Can you tell the members of the jury about your schooling?
I have a BA degree in zoology from Drew University and a master's and doctoral degree in forensic toxicology from the University of Maryland School of Medicine. I got my doctoral degree in 1993 and then moved to Florida in 1994, so I've been in this position professionally ever since.
Okay. Forensic toxicology. Can you explain to the members of the jury what that field entails?
Forensic toxicology is the application of toxicology for the purpose of the law. Toxicology is the study of poisons. My work primarily is dealing with post-mortem toxicology, behavioral toxicology, and some clinical and medical toxicology.
It's probably fairly obvious, but if we could just maybe define some of those terms. So when you say post-mortem toxicology, what is that dealing with?
Post-mortem forensic toxicology obviously deals with post-mortem or death. So in that area, as a toxicologist, I direct a laboratory that receives specimens like blood and urine from decedents that were autopsied by medical examiners. And it's the job of the toxicology laboratory to analyze those specimens for drugs as well as alcohol. Typically, tests involve examination for over-the-counter drugs, prescription drugs, and illicit drugs. Once that work is complete, then a toxicology report is issued. In my position as director of the laboratory, I also serve in a position where I consult with medical examiners and other persons like law enforcement agencies in the interpretation of those findings.
And you indicated that in your present capacity, your lab works with several different counties within the state?
Yes, it might be about 15 or 20 counties, but it's 5 medical examiner districts.
Okay, and I think you indicated it's not here, which is the 6th, correct?
That's correct.
All right, and your laboratory wasn't involved in the testing of the blood samples in this particular case, is that correct?
That's correct, it was not.
Okay, your testimony is going to center on what that result means, is that correct?
Yes.
Now, since you work with medical examiners' offices, is it fair to say that you work with law enforcement?
Yes.
Okay. So in your capacity working at that lab, you necessarily end up testifying for the state and in prosecution matters because of your position in that lab. Is that a fair statement?
Yes, my report and my name, of course, that's attached to the report appears in about 2,500 death cases per year. So over the course of my career, it's more than 50,000 cases. And many of those do involve legal investigation and some prosecutions. So just by default, I'm listed as an expert in cases, and I testify often for the state.
Okay. But in addition to that, do you also testify for the defense?
I do.
Okay.
I'm sorry. In some of my cases, I would testify for the defense. In other cases, I'll consult with the defense, even though I wasn't party to the toxicology testing.
Okay, so more because of what your laboratory does for the state, but you do testify for the defense and consult with the defense as well. Is that a fair statement?
Yes, I do.
Now, do you have any professor positions?
Yes, so I started at the university as an assistant professor, and now I'm professor. I've been professor for over 10 years.
Are you associated with any other schools or universities?
Not other schools or universities, other organizations, but not other schools, just the University of Florida. That's enough.
Okay. What other organizations are you affiliated with?
Well, I'm a member of several professional organizations, probably the 2 most important ones for the work that I do. Maybe there's a third, actually. One is the Society of Forensic Toxicologists. I'm a recent past president of the organization. And I'm also past president of the American Academy of Forensic Sciences. And finally, I'm the president of the American Board of Forensic Toxicology.
Have you published any materials?
Yes, I have a pretty extensive CV or resume. I'm co-editor of 4 books in the field of toxicology, about 45 chapters in toxicology, medical, and other textbooks, and about 110 papers in the peer-reviewed literature, covering all sorts of areas related to toxicology.
Okay. And that's going to be the subject matter of your testimony here today, is that correct?
Yes, sir.
Obviously, you're an expert in the forensic toxicology field, correct?
Yes, I am.
And how many times, just approximately, have you testified as an expert in forensic toxicology?
In the courtroom, in trial, about 350 times in my career over the last 25 years.
And has that been, obviously, you testified in the state of Florida. Is that also in federal court?
Yes, federal court, courts out of the state of Florida, and even military courts.
Now, with respect to your involvement in this case, were you asked to interpret the toxicology results of the victim, Marquise McLaughlin?
Yes, I was.
Were you provided some materials to review?
Yes, I was.
Were you provided videos showing the outside of the Circle A store as well as the inside of the Circle A store.
Yes.
And were you provided a copy of the toxicology report
Yes.
as well as the autopsy report?
Yes, it was attached.
All right, this information, did you rely upon that information in forming your expert opinion regarding whether or not Marquise McLaughlin was under the influence or impaired by MDMA at the time the shooting occurred?
Yes, I also looked at the police report, the investigation report, all of that together to place it into context.
And in reviewing all that information, are you in fact able to offer an opinion about Mr. McLaughlin's impairment or whether or not he was under the influence of ecstasy?
Yes.
The toxicology report indicated a certain level of the drug in his system?
It did.
Okay, and what was that level?
The toxicology report from the medical examiner's office indicates that the concentration of MDMA or methylene dioxymethamphetamine, that's the chemical name, was 459.5 nanograms per milliliter. In addition, its metabolite MDA or methylene dioxyamphetamine was detected, and the concentration is 37.6 nanograms per milliliter.
All right, we're probably gonna have a lot of terminology that we're gonna need to define for the jury. MDMA, is there a common name, maybe a street name that people use?
Ecstasy.
Okay, and that's what's commonly referred to as ecstasy.
Yes, maybe X as well. Most common name is ecstasy.
Okay. You indicated two different acronyms. We have MDMA and then we had MDA. Can you explain to the members of the jury what each of them is?
So MDMA is the parent drug. It's ecstasy. So if someone ingests a tablet that contains MDMA, that's the substance that we're speaking about today. Parent meaning it originates from that compound in comparison to the MDA, which is the metabolite of it. So if individual consumes MDMA, it's metabolized to MDA. It's not unusual to find both in a decedent, like we have in this case.
So when you take the drug, just through your body's metabolism, it converts the MDMA into the MDA.
Yes.
Now, this particular blood sample, do you know if it was post-mortem?
This is a post-mortem specimen.
Okay. Does that mean anything to you?
Well, yes. I think we have to be very cautious with the interpretation of the concentration of these two substances or drugs in the blood of the decedent. About 20, 25 years ago, there were a number of studies that established a phenomenon that's called post-mortem redistribution. And that's simply describing the movement of drug or drug metabolite from one area of the body into another. So it might pass out of an organ and into a vein or vice versa. But it's basically a redistribution of these compounds in the body. So it was once thought that when a person died, everything sort of became stationary or did not change. But now we know, based on these studies early on, 20, 25 years ago, and studies conducted later, that it is very likely that the blood drug concentration is going to change. So some studies have shown that the concentration goes up. Some studies have shown that it can go down or maybe stay the same. But it's likely going to change. It changes from the moment of death, so that would be the time that the decedent passed away in this case, to the time that Dr. Palma conducted the autopsy. And there's no way to freeze the concentrations or keep them static. They will change. We have no influence over that.
Let's talk about what MDMA is, okay? Explain to the members of the jury, maybe the pharmacology of the drug, what does it do?
MDMA is a classic stimulant, but don't get me wrong, it doesn't act like amphetamine or methamphetamine. It's really quite unique in that It doesn't cause excessive stimulation of the central nervous system or of the circulatory system like methamphetamine might. But what it does, it's considered to be a euphorogenic drug. So it's a drug that makes you feel well, increases your well-being. It's an empathetic drug, or well, I'll use this term. It just increases the empathy for others. It had been commonly used in raves and other types of parties where there was a desired need for sensory perception and the increase of sensory perception. So some people have called it like a love drug. It's a drug that causes one to feel comfortable with oneself and have inner peace. It's not a drug that causes one to be irritable or agitated or anxious.
It's a drug that makes someone basically feel good.
Yes.
And want to be around others.
Yes.
And I would assume that if people take it to go to raves or clubs, it's more of a social drug?
It is a social drug. It's very different than other stimulants.
So when you hear, amphetamine, I think you just indicated that before, it's not one that makes you aggressive and you flip out and you go crazy and you have superhuman strength. That's not what this drug is.
It is not.
In fact, have there been some studies for therapeutic uses of MDMA?
Yes. So many years ago, 15, 20 years ago, it had been suggested that MDMA may be useful in treating PTSD. And it's currently in phase 3 trials in humans as a drug to treat very severe PTSD, and it appears to be a good treatment for individuals who suffer from severe PTSD. Obviously, if someone suffers from PTSD, you would not want to use a drug that increases one's inner level of anxiety or irritability. So perhaps one day it may be used as a drug, therapeutic agent to treat PTSD.
Okay. And are you familiar with the different phases before a drug's approved?
Yes, and this drug is in phase 3, which means it's the concluding trial before the FDA would look at the drug and determine if it could be used therapeutically.
Now, with respect to the actual result in Mr. McLaughlin's blood, does that indicate to you that he had recently used it?
Yes, for sure.
When you ingest something, alcohol, drugs, does that mean it immediately affects you, or is there some type of absorption that has to take place before you feel the effects of the drug or alcohol?
A drug like MDMA that you ingest orally, the onset of effects would be roughly 30 minutes to 45 minutes. As soon as it reaches the bloodstream, the individual would feel that effect. It's quick.
With respect to the level in Mr. McLaughlin's blood, anything unusual about that amount? I mean, is it an excessively high amount?
No, it's what I would characterize as a typical amount for someone who is using the drug, MDMA, recreationally, and it is consistent with the recent use of the drug. The metabolite is present, so we know it wasn't ingested just minutes before his death. There had to have been time for the metabolite to be formed.
Have you ever read studies or personally been involved with, read literature about people who have overdosed to a toxic level, so they have like a severe reaction to MDMA?
Yes. Well, in the laboratory over the years, we have seen a handful of cases associated with MDMA intoxication and death. It's not very common. It's not like a methamphetamine overdose or other stimulant overdoses. It can occur, particularly if the individual consumes too much. That doesn't appear to be the situation in this case, though.
The number, or the reading in this case, was 459. In those levels where it's toxicity or overdose, what would be the level you'd expect to see in those cases compared to what we have here in Mr. McLaughlin?
Generally higher, even much higher, like 1,000, 2,000, 3,000 nanogram per milliliter.
Okay, so this is much, much less.
I say it's less.
Okay.
Yeah.
Now, you had an opportunity, you said, to review the videos, correct?
I did.
All right, so did you review the video where Mr. McLaughlin got out of the vehicle and walked to the store?
Yes,
All right, and you saw that he was with his son.
he was.
In looking at that video, was there anything that gave you the impression that Mr. McLaughlin was having a severe, acute reaction to the ecstasy?
No, none.
It appears as though he got out of the car normally,
Yes,
walked up the sidewalk normally,
yes,
wasn't looking up at clouds and sun and hugging himself or anything like that?
no, not that you would do that necessarily, but he just looked completely normal.
Okay, and that's kind of my point. He didn't do anything unusual from the time he got out of the vehicle to the time that he went to the store.
Nothing.
All right, didn't try to open a piece of glass as opposed to opening the door?
No.
All right. Did you then watch the video when he was inside the store?
Yes,
And did he appear to you to be so under the influence of the MDMA that he couldn't pick out any items?
no,
Okay. Did he have any difficulty standing in line to pay for the items?
no. Again, he looked apparently completely normal.
Okay. Wasn't freaking out, fighting with people, jumping over the counter, stealing things?
No, and I wouldn't expect that in an individual consuming MDMA.
Okay. Because that's not what that drug does to people.
That is correct.
And you learned in reviewing all those items that there came a point in time when people became aware of a confrontation that was in the parking lot.
Yes,
Okay. And you read statements from witnesses that indicated that that altercation in the parking lot went on for a period of time, maybe a minute or so.
yes, I watched it.
Okay. And when there came a point in time when a witness, you wouldn't know him, but named Robert Costelli, you probably saw his name in the reports, came inside the store and told the cashier that there was an altercation outside, something was happening. You remember reviewing that?
Yes,
Okay. And at that time, in conjunction with the video you were watching, did you see Mr. McLaughlin put down his items and begin to walk out the store?
yes, he did.
Now, would you say that that would be a normal reaction to hearing that some...
Objection, Your Honor, if we could approach.
Yeah, I'll sustain the objection.
Thank you, Your Honor.
All right. From what you saw, Mr. Costelli going in and telling the cashier what had happened, the way that Mr. McLaughlin reacted by walking out the door, is that consistent with someone who is having acute adverse reaction to MDMA?
No, everything seemed normal.
When he exited the store, he being Mr. McLaughlin, did he go flying down the sidewalk and running out there and jump on somebody?
Objection, Your Honor, for the jury to determine.
Did he run down the sidewalk and jump on someone and tackle him?
No, he did not. Again, it looked completely normal.
When Mr. McLaughlin left the store and was heading back towards where the altercation was, okay? I know, again, it sounds like a silly question. Was there anything about him walking down the sidewalk that gave you the impression he was having some type of acute reaction to MDMA?
None at all.
Obviously, you saw that Mr. McLaughlin shoved an individual away that was near his girlfriend, correct?
He did. That's evident on the video.
Did you see another individual, and this would be Mr. Costelli when you watched the video, that was out there at the same time?
Yes.
Okay. Now, for the sake of this question, I think we can all agree that Mr. Costelli was not on MDMA. So there's no testimony, no evidence to show Mr. Costelli was also taking MDMA. Did you see when the defendant took out the firearm, when he was on the ground?
Yes.
Okay. Did you see Mr. Costelli react when that firearm came out?
He backed away very quickly.
Okay. What would be the word if someone was not taking MDMA, like in a laboratory setting or a testing? What would you call that person?
It's a reflex. It's a normal reflex or response to something that could be very adverse.
Okay. Now, if Mr. Costelli wasn't under the influence of ecstasy...
Object, Your Honor, to the relevance of Mr. Costelli. He's just a witness to what occurred. I'm not sure what the relevance is of Mr. Costelli.
I'll rule objection, but we won't get to Mr. McLaughlin, though.
Okay, thank you. You saw Mr. Costelli react appropriately when the firearm came out, correct?
I did.
All right. And in watching that same video, did you watch how Mr. McLaughlin reacted when the firearm came out?
It was almost synchronous at the same time where he backed away.
Okay. So Mr. Costelli recognized the danger at the same time Mr. McLaughlin did, and they both began backing away.
Yes.
Again, I'm going to object now.
I'll sustain the objection. All right, let's move on to something else.
Mr. McLaughlin's reaction when the firearm came out, is that consistent with someone who's having a severe acute reaction to MDMA?
Can you repeat that?
When Mr. McLaughlin saw the firearm and he began backing up, is that someone who appears to have having a bad reaction to MDMA?
No, I think that's a normal response, is to back away.
I don't have any further questions. Thank you.
Thank you. Cross-examination. Okay. Break until 3 o'clock, okay? Which is about 12 minutes by the courtroom clock.